Well, let me first off say that Mr. Um, I'm not sure I'm saying it right, but he understands that he enjoys a great deal of support within his family, obviously, but among other members of the community as well. He's a person that people believe that they can count on and they can rely on. And he's portrayed as someone who is, what's the right word, Your Honor? I'm sorry. Someone who is reliable and would, quote, give you the shirt off his back type of thing. That's consistent with my observations of him. It's important that I want the court to understand the rash nature of his actions in this case are, while they're obviously unfortunate and obviously for something for which he is repentant, the way his behavior is described in here was a little bit shocking to even Levi himself when he read another person's account of the events in question. And I think he showed a remarkable level of maturity and insight when he was able to see how his actions impacted other people, including the police agencies that were involved, including the victim in this case, with whom he was in an interpersonal relationship. I think it's easy to assume that people have the ability to do that. They have the empathy, that they have the ability to see through the eyes of other people. But I don't think that's something that is innate. I think it's something people have to acquire and learn as they go through life. He's only 24 years old. I think it's important for him. He wanted me to say a couple of these things, so I will, that this is not how he wishes to be defined as a person. And I can't say as I blame him for that. What you see in the facts in this case is someone behaving rashly, behaving emotionally, and most of all, someone who clearly does not appreciate the nature and the character and the scariness of his behavior. And in this case, that recklessness resulted in, well, not the worst possible scenario, obviously, Your Honor, because thank God neither one of them was killed, but a situation in which someone he cared for deeply was seriously injured as a result of an automobile accident that he caused. Why? Because he was behaving in a dramatic, flippant sort of way. It was not his intention to crash his car that day. That may go without saying, okay? But I want it to be emphasized that while he intended to scare the victim, he did not intend for her to be harmed in any way, and he did not intend for his vehicle to become wrecked in the way that it did. That's easy to say as you look back and say, well, you know, I didn't really mean to. But that's what reckless behavior is. It's a momentary lack of regard for the safety and the welfare of other people. And that's what happened here. It's a lesson that I think people have to learn, like I said. Unfortunately, Levi chose one of the hardest ways that you can imagine to learn that lesson. That thing that seems obvious to most of us in the room clearly needed to be imparted to him and was in a very harsh way. Now, I understand that a lot of people hear me say things like that. Maybe the court does too, I don't know. And they get the impression that I'm trying to make some sort of statement that Levi's the victim here. That is clearly not the case. I will say this, if Levi had this to do over and there had to be someone getting injured as a result of his behavior, he'd much prefer that it was him and not her. It may seem obvious again, but I think it's compelling to say to the court that he does possess that level of insight and has learned that lesson from what happened that day. The other thing that he knows for certain is that there will be a sanction for his behavior. We've contemplated that from day one. We were able to enter into what is quite obviously, I mean, again, I think I'm speaking in terms of things that are fairly obvious to even a casual observer, a favorable resolution of the case. And he was able to secure his pretrial release from jail so that he could attend to personal matters and work and that sort of thing prior to coming back here for what we believed could be a jail sentence. Now, the recommendation is just for that, for a jail sentence of 150 days. I would note he has 40 days credit. That does not appear to regard the intermediate sanction that he scored here. Now, again, I don't presume to think for the department or to make suggestions as to how they ought to write these reports or anything like that. It just strikes me that on a 0 to 9 guideline, I would like to know, I guess, and maybe the court can flesh this out because I'll explain why in just a minute, what factors they would apply to this that would seek to overcome the presumption that he not served a jail sentence in this case. That's not identified in the report with any degree of specificity. And I want to say, having said all of that, that I don't fault the department for it at all. I simply point that out. I'm left with essentially an allegation that I don't know the basis of and I can't really refute. Now, again, it may seem obvious to certain people, maybe to everybody but me, as to why a jail sentence is appropriate here, specifically one of that magnitude. I don't know. I don't know how we get there. Now, I'm aware that there are situations where the guidelines don't adequately reflect the nature of the crime or the extent of the impact that his behavior had on other people. Things like that, that in addition to overcoming that presumption in an intermediate sanction would allow the court to impose such a jail sentence. I would leave it to the court's discretion, and I trust the court's discretion in that regard. Thank you.
Thank you.
This was not an unfortunate event. This was, frankly, one of the scarier reports I've read. This was an intentional act. This was not a scare tactic. This was an intentional act. He said to her, you know what, I should just crash the car. And then he sped up. She asked him to stop and slow down multiple times. He just looked at her and said no before swerving into the ditch. He said they talked about ending it. She denied that. He did this. He did this purposefully and intentionally. It wasn't a mistake. It wasn't an accident. Mind-boggling how scary this was and how scary it had to be for her in that car that night. Talking to him and having him speed up and swerve across the road and hit a telephone pole. It's incredible to me. It's incredible to me. Mr. Oung is 24 years old. He has no employment history. He's not working. He's not taking responsibility for his life. I believe he has a child. This is the time for him to grow up and stop this. This is not his first time in court. He's been given opportunities, and yet he's doing nothing except, frankly, he's a menace. This was so dangerous. We're lucky no one else was on the roads. We're lucky it was at the time of night that it was, so that no one else was injured. And frankly, to say that if he had to do it over again, he hopes it would be him that was injured. I would hope he would never do this again. If he had it to do over again, I hope he wouldn't do it again. This was extremely dangerous, and frankly, it was just mean. I agree with the recommendation. I think there should be a jail sentence, and I'm going to ask the court to impose it. And I will note, this is me. The victim would like the no contact order lifted, and so I think I should let the court know that. But for public safety, I think if we could do more, I would ask for more. I think a public safety aim, I think he's dangerous. Thank you.
All right, Ms. Oung, your opportunity to say something if you wish to do so. Is there anything you wish to say at this time, sir?
There is one thing. I have been working. Actually, I got a job probably a week after I got out.
Okay.
I am working over at Hutchinson.
All right. Good. Good. All right. I understand some of those things that Mr. Harrison was discussing. That's what he's supposed to do. And first of all, let's take a look though at the facts. So you're out in a rural part of the county out here in Clam Lake Township, and decided to, when your girlfriend or fiance challenged you about where you were because you had gone out of your way to take somebody home, and she asked you questions and accused you of having another relationship, your response was to flip out, threaten to drive and crash the car, then decided to go at a high rate of speed, exceeding the speed limit by at least 23 miles an hour, and driving recklessly. So while you may not have intended the harm, you intentionally drove in a wanton, willful way with disregard if there was going to be harm. You may not have looked at her and did something and smashed her intentionally into a pole to break her pelvis, but you did your acts knowing what was likely to happen. So I don't really there's not much of a difference there. And I'm going to tell you here what I see, and I like to give some cases a theme, and yours is selfishness. Selfishness and immaturity. Now, when I look at the history, then I wonder, is there any other history of selfishness and immaturity? Lo and behold, there is. You are 24 years of age. You've got a juvenile adjudication for a sexual assault. Now you were successfully discharged from your probationary period there. Good. And you did make it about a year before you picked up another case that started off as an arson, but I'm sorry, it was resolved with an arson. And you were given a chance. Looks like you were placed upon some kind of delay. It doesn't really say, yes, it's delay of sentence. So you're given a chance. And in that one, thankfully, you successfully completed that delay. I found it interesting that apparently at or about the same time, you also got an HYTA, a Homeless Youthful Training Act, which you lost that Homeless Youthful Training Act. So you were able to complete one, you failed to complete the other. But so far, you got a CSC for an act of selfishness. You had a arson, violence and destruction of other people's stuff, followed up by a larceny, stealing other people's stuff, then followed by an illegal entry or breaking and entering, violation, disrespect of other people's stuff, and you were unsuccessfully discharged on that probation. So what I see from this is a young man who is not getting it, acts selfishly and like a child. You may have a job now, and I appreciate that you do, and it does say on here that you began working at Hutchinson's back in September. When I look at this, though, you got a relatively sporadic history of employment. I wonder what you're doing with yourself and what your plans are and where you're going, because right now your conduct is unacceptable. You are putting people in danger because you decide to act like a child. You're no longer a child. You decided to go driving recklessly down the road, putting somebody at risk, saying, right here, on CFJ 284, page 3. Well, we might as well get into an accident. Just say F it and end it. Allegedly that you guys were talking about killing yourselves, and so you decided to do it. Why? Because the young lady asked if you were having an affair with somebody else. That sounds really silly. Why don't you just say no or say yes or work it out instead of acting like a crazy person, speeding through the country on back roads, exceeding the speed limit at higher rates of speed, putting her at risk. So, yeah. Court sentences the defendant, and I find that even though this is an intermediate sanction, so that there are reasonable grounds based upon the defendant's repetitive acts of violating probation. Also, even though he succeeded in a couple, he had some other violations, but also his acts of dangerousness that put people in other acts, right, in the acts of violence that he creates, and his repetitive acts of selfishness as he doesn't seem to get it or change his approach to life. So the court adopts the terms and conditions for that 24 months of probation that are listed on CFJ 145 pages 2 and 3. And I find that those are well suited for rehabilitative purposes. Specifically, there are some terms or conditions there regarding controlled substances. And it appears that the defendant has been using controlled substances, marijuana specifically, as well as alcohol, well before he became 21 years of age, which means I'm concerned he's now starting to develop some level of potentially addiction. It says unlikely in his compass chart, but it definitely seems to be, in my mind, apparently influencing his ability to make some good choices. So, all right, the court assesses a $68 state minimum fee, $130 crime victim's right fund fee, $300 court cost, $300 attorney fee, $500 fine, supervision fees of $30 a month or $60 a month if there's any electronic monitoring. If the victim is asking to have that no contest issue restriction removed, then we can go ahead and remove that from the order. Well, Mr. Let's stop acting selfishly. It's silly, and you're putting other people in danger. Court sentences the defendant to 180 days of jail, and the court gives the defendant 40 days of credit. All right, this court finds that sentence is reasonable and proportionate, and that there are reasonable grounds as I've discussed. And it put the victim into an injury where she broke her pelvis and couldn't even straighten her legs when they had to, quote, extract her from the car. You can put this behind you. You so choose. Hopefully, we no longer see you come into the court for bad reasons, but hopefully, while working with Ms. Simmons, you figure it out